Imagine waking up one morning in 2026 and realizing the rules that control your job, your home, your immigration status, your privacy, even your personal safety in public places have all changed without you noticing. A single missed document could affect your right to stay in the country. A landlord could no longer evict you overnight. Your employer could no longer cut your hours without warning. And entering a stadium or cinema might feel more like airport security. These laws claim to protect you, but each one silently reshapes how much control you truly have over your own life.
Number 10. Terrorism Protection of Premises Act, Security versus Privacy in Public Spaces. The 10th law taking effect in 2026 is the Terrorism Protection of Premises Act, commonly referred to as Martin's Law, aimed at improving public safety by requiring venues to take stronger security measures against potential attacks. Places such as arenas, cinemas, stadiums, concert halls, universities, shopping centers, museums, places of worship, and major event venues will need to introduce risk assessments, evacuation planning, staff security training, bag check systems, and emergency communication protocols. The goal is to create a safer environment where large gatherings are better protected, giving staff and visitors clear guidance on what to do during emergencies. Many venues have already begun pilot programs, but the law makes compliance mandatory starting 2026. Alongside stronger physical security, the law expands the use of monitoring systems, digital access control, and incident reporting technology. While these measures improve safety, they also raise concerns about privacy and personal data, especially in locations where surveillance becomes more frequent. Individuals may experience more security checks, identity verification requests, and digital tracking when entering certain venues. Event organizers and businesses will be responsible for securely handling personal data collected during safety procedures and may face penalties for misuse or negligence. The challenge in 2026 becomes finding the right balance between preventing attacks and respecting civil rights. This reform matters because it changes how people interact with public spaces, shifting security from being mostly invisible to being an everyday requirement. For some, this brings relief and reassurance. For others, it generates discomfort about increased monitoring. Either way, the practical impact is undeniable. Security screenings, emergency training drills, and structured crowd management systems will become a permanent part of events and entertainment across the UK. With this final law, the 2026 reforms collectively reshape work, housing, immigration, privacy, and personal protection. Like, subscribe, and comment if you want a full documentary-style breakdown of all 10 laws in one powerful script.
Number 9. Redundancy protections and collective consultation. Losing your job shouldn't mean losing your security. The 9th law, arriving in 2026, brings a major upgrade to redundancy protections, ensuring workers are not pushed into unemployment without fair treatment or compensation. Under the new rules, employers who fail to follow lawful redundancy procedures can face doubling of protective awards, giving workers stronger financial security during transition. Companies must now provide clear, written reasoning for redundancy decisions and prove that job cuts are based on genuine business need rather than performance manipulation or cost-cutting disguised as restructuring. This prevents situations where employees are chosen unfairly due to personal bias, whistleblowing, age, disability, pregnancy, or union membership. The new law strengthens transparency and stops organizations from using redundancy as a loophole to remove unwanted staff. The legal obligation surrounding collective consultation is also reinforced. When a business plans to make multiple redundancies, it must open a formal consultation process with workers or union trade representatives well in advance, share relevant planning documents, and allow employees to challenge proposals. Employers cannot proceed with mass layoffs without considering alternative measures such as redeployment, retraining, or modified job roles. Every consultation step must be documented, and failure to follow correct procedure can lead to legal and financial penalties. This gives employers the chance to participate in decision-making rather than receiving sudden, life-changing announcements without warning or negotiation. These changes reshape the way redundancy is experienced in the UK by prioritising dignity, fairness and stability during one of the most stressful moments in a person's career. Redundancy will no longer be carried out overnight and compensation will no longer be symbolic. Workers will now have time, financial support and legal protection to plan their next steps instead of facing abrupt insecurity. Anyone employed in a sector prone to restructuring should start reviewing redundancy clauses and union representation options to stay informed. Like, subscribe and comment if you want Section 10 on surveillance and security law explained next.
Number 8. Decent Homes Standard. Every tenant gains the right to a safe and livable home. The 8th law, taking effect in 2026, links directly to housing quality through the Decent Homes Standard, making it illegal for landlords to rent out homes that do not meet minimum living standards. This requirement goes beyond superficial repairs and focuses on the health, safety, and structural integrity of rental properties. Landlords will be legally obligated to ensure reliable heating systems, adequate insulation, working ventilation, mold prevention, clean water access, safe electrical wiring, and hazard-free interiors. Local authorities will have stronger powers to inspect properties, issue fines, and force repairs when standards are ignored. For tenants, this means that poor living conditions can finally be challenged without fear of immediate eviction. The law also introduces a new complaint pathway, giving renters a faster, less intimidating process for reporting unresolved repairs or safety concerns. Housing providers will face consequences if they neglect urgent issues for long periods or repeatedly postpone maintenance. Families with children, elderly residents and disabled tenants will receive priority protection, reducing the risk of respiratory illness, injury and mental stress caused by unsafe housing. Landlords must maintain documentation that proves their compliance and inspection history, and failing to upgrade substandard properties will no longer be a profitable choice. These changes matter because a home is not just a rented space. It directly affects security, health, and dignity. For years, many tenants had to tolerate damp walls, unsafe electrics, or unreliable heating just to avoid losing their tenancy. The 2026 reforms close that gap by enforcing a minimum standard that protects people rather than profit. If you are renting, start gathering evidence of hazards or overdue repairs now so you're prepared once the law becomes active.
Number 7. Trade union rights and industrial action. Stronger collective power for workers in 2026. The 7th law, coming into effect in 2026, transforms how trade unions operate and how workers participate in industrial action. The new legal framework expands the right of employees to join trade unions openly, without fear of retaliation, making union membership a protected characteristic in workplace decisions. Employers will be prohibited from using promotions, scheduling, or performance reviews to discourage union involvement. Workers in unionized workplaces will also gain easier access to representation during disputes, disciplinaries, or contract negotiations, preventing isolation and power imbalance during conflict. Another major aspect is the shift in how industrial action ballots are conducted. The law introduces more transparent rules on strike ballots, digital voting possibilities, and faster certification processes, reducing delays that previously weakened collective action. While minimum service requirements may apply in certain essential sectors, the overall structure makes collective bargaining stronger, not weaker. Employers will be required to engage in good faith consultation with unions during major organizational changes, including pay revisions, redundancy planning, and restructuring. Attempts to bypass unions during negotiations will carry legal consequences, reinforcing fairness within the workplace. These changes matter because individual workers rarely have enough leverage to challenge unfair practices alone. Strengthened trade union rights mean that negotiating wages, working hours, and fair treatment becomes a shared effort rather than a private struggle. Businesses that value their workforce will have opportunities to build transparent agreements without escalating to conflict, while workers will no longer have to choose between their jobs and their dignity. Anyone watching this video should consider whether their workplace has a union presence and whether representation could support them during future negotiations. Like, subscribe, and comment if you want Section 8 about the Decent Home Standard explained next.
Number 6. Workplace harassment and safety protections. Employers become legally responsible for prevention. The sixth law arriving in 2026 strengthens protection against sexual harassment and third-party harassment in the workplace, shifting responsibility onto employers rather than victims. Under the new rules, every organization must actively prevent harassment rather than only reacting after an incident occurs. Employers will be legally required to provide clear reporting systems, timely investigation processes, and visible prevention policies. Failure to do so can result in fines, legal action, and compensation awards. These protections apply to harassment from managers, colleagues, clients, customers, contractors, or any third party, closing the loopholes that previously left workers exposed in public-facing jobs such as hospitality, retail, healthcare, and transport. Another key part of the reform is that victims will not need to prove repeated behavior in order to be protected. A single significant incident can now qualify for legal protection. The new rules also require companies to conduct regular risk assessments and employee safety training, ensuring that prevention is built into workplace culture instead of being treated as a minor HR formality. Employers will no longer be allowed to ignore reports or informally pressure employees to stay silent for the sake of reputation. Retaliation against anyone who reports harassment will be treated as a serious violation, bringing automatic legal consequences. These changes are designed to make every employee feel safe, respected, and valued, regardless of gender, seniority, or role. Workplaces that once normalized inappropriate behavior, uncomfortable comments, or verbal intimidation will now face legal accountability if they fail to act. Employees should start familiarizing themselves with their organization's reporting system and documenting incidents immediately if needed. Respect and dignity are not optional benefits, they are basic rights.
Number 5. Stricter immigration and suitability rules. Small mistakes can cost legal status in 2026. The fifth law change focuses on immigration, bringing far tighter suitability and compliance rules for migrants, students, and international workers starting in 2026. The government is expanding its authority to refuse or cancel visas based on a wider range of factors, including overstaying by even a short period, incomplete documentation, unresolved financial records, or past rule breaches on previous visas. Decisions will increasingly rely on digital tracking systems, meaning immigration status will be monitored more closely throughout a person's stay. Students and workers will face stricter checks on course attendance, employment authenticity, and sponsor compliance, making immigration rules harder to navigate without paying close attention to deadlines and paperwork. The new changes also impact families and long-term residents. Spousal and dependent visas will be reviewed with higher financial requirements and proof of relationship standards, and government agencies will cross-verify housing arrangements, employment income, and sponsorship before approving renewal. These updates are aimed at reducing overstaying and visa fraud, but they also place pressure on genuine migrants to consistently maintain evidence of their eligibility. Even small delays in submitting forms, reporting address changes, or updating work information could now affect legal status. Deportation enforcement powers expand under these rules, and appeals may become more challenging if a breach is documented. These laws matter because immigration is not just paperwork. It represents people's homes, careers, and futures.
Migrants will need to be more organized than ever to protect their residency and prevent unintentional violations. Setting reminders for visa renewals, saving proof of employment, and keeping copies of bank statements and rental agreements will become essential routines. Anyone planning to study, live or work in the UK beyond 2026 should begin preparing for stricter checks instead of waiting for renewal time.
Number 4. Renters' Rights Act 2025, effective May 2026. No-fault evictions come to an end. The fourth law change arriving in 2026 is the Renters' Rights Act, bringing one of the biggest shifts the UK rental market has seen in decades. From 1st May 2026, landlords will no longer be able to remove tenants without reason through Section 21 no-fault evictions. Every eviction must now be backed by a lawful, evidence-based justification, such as unpaid rent or property misuse, and tenants will have the right to challenge the decision fairly. This gives renters a sense of housing security, stopping the cycle where people were forced to leave homes suddenly due to rent increases or landlord decisions unrelated to behavior. The new law also strengthens notice periods and provides better safeguards for families with children, students, and long-term renters. Another key shift is the legal requirement for landlords to meet new housing quality standards, including safe heating, proper insulation, mold control, and structural safety. Properties that fail minimum living standards can be reported through a streamlined complaint system, and authorities will have more power to issue fines and enforcement notices. Renters will also have stronger protection against retaliatory eviction attempts when raising repair complaints. For tenants, this means the right to live in a home that is safe, hygienic, and maintained consistently, rather than battling landlords for repairs every winter. These reforms are designed to rebalance power between landlords and tenants, addressing years of stress caused by unfair removals and neglected living conditions. Landlords who maintain professional standards will benefit from clearer rules, while tenants gain transparency, safety, and emotional stability. With 2026 approaching, renters should start documenting repairs, learning their rights, and reviewing their tenancy agreements to identify outdated clauses. Housing is not just shelter, it is the foundation of mental well-being and financial security, and this law recognizes that.
Number 3, ban on fire and rehire and 0 hours abuse. No more job security traps. The third major law for 2026 targets the controversial practice known as fire and rehire, where employers used to dismiss employees and rehire them on worse contracts when they refused pay cuts or reduced benefits. Beginning in 2026, this tactic becomes illegal, blocking companies from forcing workers into disadvantageous terms through intimidation. Any change to working conditions must now follow a fair negotiation process, with employees protected from dismissal as retaliation for resisting unreasonable reductions. This law reinforces job security and prevents sudden income drops that push families into financial instability without warning. Another key aspect of this reform addresses 0 hours and unpredictable contracts. For years, many employers controlled income by offering shifts at the last minute, cancelling them upon arrival, or keeping workers on standby without pay. Under the new law, employees will gain the right to predictable working hours, minimum notice periods for shift cancellations, and compensation for short-notice withdrawal of work. Workers can also formally request a stable work pattern after a short qualifying period, and companies must justify refusals with written, lawful reasoning. This protects vulnerable sectors where income insecurity is highest, including retail, logistics, hospitality, healthcare support, and student jobs. These reforms matter because they shape the core stability people need to plan their lives. Job contracts will no longer operate like gambling, where shifts depend on a manager's mood, or the risk of punishment hides behind every refusal. Workers will not be forced to choose between loyalty and financial survival, and employers will be held responsible for transparency and predictability. If you're watching and want to prepare for this law, start reviewing your contract and shift pattern now so you know where your rights begin in 2026. Like, subscribe, and comment if you want Section 4 on rental rights explained next.
Number 2. sick pay, parental leave, and flexible working, human rights inside the workplace. The second law change, coming in 2026, focuses on sick pay, parental support, and flexible working rights, addressing the areas where most workers previously struggled in silence. From 2026, statutory sick pay begins on day one, instead of making employees wait and lose income during illness. Parents also receive stronger protection, including day one parental leave eligibility, extended leave options for premature birth, and guaranteed time off for neonatal care. Flexible working shifts from being a favor to a legal right, giving every employee the power to request reasonable working patterns that support their personal life, caregiving duties, or medical needs. These reforms put human well-being at the center of employment rights, instead of treating it as an extra benefit. A major shift lies in how employers must respond to flexible working requests. Companies will be legally required to follow a transparent, evidence-based decision process, not automatic rejection. If an employer denies a request, they must provide clear written justification, while workers will no longer be limited to one request per year. This law aims to reduce workplace burnout, family conflict, and prevent employees from being pushed out due to rigid structures. It also gives workers more control during life-changing moments, such as pregnancy, adoption, illness, disability, or caring for aging parents. These changes directly protect the well-being, family life, and mental health of workers across the UK. Millions who previously had to choose between income and responsibility will now be covered by enforceable rights. If your workplace still follows old rules, 2026 marks a turning point worth preparing for. Use this law to secure balance, protect your income, and maintain dignity in both your professional and personal life.
Number 1. Employment Rights Bill. Day one protection for every worker. The first major law set for 2026 is the Employment Rights Bill, reshaping the foundation of workplace protection. It introduces day one rights for millions of employees, meaning you are legally entitled to sick pay, parental leave, redundancy protection, and protection against unfair dismissal from the very first day of employment. This removes the long waiting periods that previously left workers unprotected during the most vulnerable stage of their job. The reform also strengthens transparency in workplaces, requiring employers to provide clear, written terms, defined responsibilities, and predictable shift information without manipulation of unpredictable scheduling systems. Another powerful change under this bill is the reforms surrounding zero-hour contract and unpredictable shifts. Employers will now have limits on short-notice shift cancellations, forced unpaid waiting periods, or sudden drop in working hours. Employees gain the right to request stable working patterns that align with their family, health, and commuting needs, while companies must justify and record any refusal based on lawful grounds. This shift aims to reduce underpaid labor disguised as flexibility, helping workers achieve income stability, mental security, and work-life balance. The law also expands protections against victimization, discrimination, and dismissal linked to flexible working requests. This change matters because it directly affects basic dignity at work. For the first time, millions of part-time, shift-based, care, warehouse, gig, and retail workers will be legally covered from day one instead of waiting months for eligibility. The bill places responsibility on employers to maintain fair practices rather than leaving workers to navigate uncertainty alone. If you're watching this video, take a moment to ask yourself whether your current job aligns with these 2026 legal protections, and if not, be ready to exercise your rights. The 2026 legal shifts redefine everyday life in the UK in ways that go far beyond courtroom language or political debate. These laws reach into personal space, the workplace you depend on, the home you live in, the immigration status that determines your future, and the public areas where you spend your free time. Some of these changes bring increased protection, while others demand stricter compliance and tighter behavior from individuals. Whether someone is a worker, tenant, student, business owner, migrant, or parent, no one will remain untouched by this new legal landscape. The most important step from here is awareness. The people who understand these laws early will be able to defend their rights, plan strategically, and avoid life-changing consequences that catch others by surprise. Ignoring these laws doesn't stop them. Understanding them gives you power. Power to question, to prepare, and to respond before decisions are made for you without your knowledge. If you want to stay secure in 2026, this is your moment to learn, not later when it's too late. If you want breakdowns of each law in simple terms, real examples, and weekly updates on future policy changes, hit like, subscribe, and comment which law worries you the most so we can cover it first.